Counsel and judges, just give us 2 minutes while we make a necessary phone call. Thank you.
Good day, Mr. Shrika.
Hi, good afternoon.
All right, we are hearing you and seeing you quite clearly. Thank you.
Madam Deputy Registrar, can you please commence the proceedings?
Thank you, President Saunders. Caribbean Court of Justice, Appellate Jurisdiction, an appeal from the Court of Appeal of Barbados, judgment delivery in BBCR number 3 of 2023 between Shawn Weekes and the state. The members of the delivery panel are Mr. Justice Saunders, President and Presiding Judge. You're on mute, President.
Yes, good afternoon, Counsel.
Yes, Mr. Justice Anderson.
Good afternoon, Counsel.
Madam Justice Rajnath-Lee.
Good afternoon, everyone.
Mr. Justice Barrow.
Good afternoon.
And Mr. Justice Burgess.
Good afternoon, Counsel.
May we have the appearances, please? Thank you.
If it pleases this honorable court, I'm Andrew Pilgrim, and with me is Marty Garnes, as we were before.
Yes, good afternoon again.
Good afternoon, Your Honors. If it pleases this honorable court, I am Neville Watson, and I continue to appear with my learned friend, Mr. Romario Straker.
Yes, good afternoon, Mr. Watson.
Good afternoon.
The judgment in this matter was written by Madam Justice Rajnath-Lee, and I will invite her to read a summary of it.
Thank you very much, President, and good afternoon to everyone again. I will read a summary of the court's judgment, as President has mentioned. This summary is not intended to be a substitute for the judgment of the court or to be used in any later consideration of the court's judgment. On the 29th of October 2000, Leo Callendar, the deceased, was murdered. Shortly after the incident, Shawn Weekes, the appellant, left Barbados, traveling first to St. Lucia, then to Canada, and finally to the United States of America, the USA, where he remained until his return to Barbados in 2011. It is unclear whether he was deported or extradited from the USA. He was promptly arrested at the airport upon his return on the 20th of October 2011 and charged with murder 2 days later. The appellant was indicted for the murder of the deceased on the 21st of July 2016. The trial commenced before Justice Graves on the 8th of October 2020. The main witness for the state was Miss Joanna Craig, who owned a small shop which stood adjacent to her home at Crane, St. Philip, where the incident took place. Miss Craig was at home plaiting her daughter's hair when she heard a commotion. When she looked outside, she saw the deceased trying to crawl up the stairs leading to her shop. She saw the appellant standing over the deceased with a gun in his hand. She called out to the appellant, whom she knew since he was born, saying, "Why you don't behave yourself? What are you doing?" Then she saw the appellant raise the gun, which caused her to pull back in her door. Thereafter, she heard about 3 gunshots, and she saw some men chasing after the appellant. 3 other witnesses placed the appellant at the shop at the time of the incident. All 3 witnesses testified that they observed an object in the appellant's hand. The appellant elected to give an unsworn statement from the dock. The appellant related that he was in the company of 4 other men lying on the block at Crane when the deceased and another man walked past them. The deceased was brandishing an orange-handled scissors and made a comment to the effect that he was coming for them just now. The appellant and his associates cursed at the deceased and took up some rocks, bottles, and pieces of wood and followed the deceased to the shop. On seeing them approach, the deceased pulled the scissors. The appellant threw a bottle which struck the deceased. Everyone then rushed the deceased. Mr. John Bennett came up with a Collins. On seeing this, everyone started running, including the appellant, who stated that he ran in the direction of the block. While running, he heard explosions coming from the direction of the shop. On the 16th of October 2020, the appellant was convicted of the murder of the deceased. On 28th May 2021, he was sentenced to life imprisonment and ordered to serve a minimum term of 28 years, less 9 years for the time spent in custody, leaving a term of 19 years before becoming eligible for release. The appellant appealed both his conviction and sentence to the Court of Appeal of Barbados. On 8th of August 2023, the Court of Appeal substituted the conviction of murder with manslaughter pursuant to Section 5 of the Criminal Appeal Act, Chapter 113A, on the basis that the trial judge should have left the issue of provocation to the jury. The Court of Appeal also resentenced the appellant to 9 years imprisonment to run from the 28th of May 2021. Special leave to the Caribbean Court of Justice, the court, was granted by order dated 19th of December 2023. The appellant filed his notice of appeal on the 29th of December 2023, relying on 7 grounds of appeal. These grounds asserted that the Court of Appeal erred in law: 1, when they found that a detailed direction on circumstantial evidence was unnecessary and would have confused the jury; 2, when it held that the appellant did not suffer prejudice due to the delay; 3, when the justices of appeal failed to consider that the trial judge should have conducted a culpepper inquiry prior to commencement of the trial; 4, when the justices of appeal found that 24 years was an appropriate starting point, and so the resulting sentence was wrong in principle; 5, when they refused, failed, and or neglected to determine one of the appellant's grounds of appeal; and 6, that they erred in law in reasoning on the applicability of R against Bonzi in Barbados. The appellant argued that in the circumstances of this case, and in the light of A, the unreasonable delay in bringing the case to trial, and B, defense counsel's response to the question of whether she intended to call any witnesses, the trial judge was under duty on the court's own motion to have embarked on an inquiry to ascertain the impact on the delay on the appellant's ability to present his defense and to receive a fair trial. Accordingly, it was argued the failure of the trial judge to conduct such an inquiry amounted to an unfair trial. Rajnath Lee, who authored the lead judgment of the court, referred to the court's decision in Gibson against the Attorney General, where the court considered the reasonable time guarantee contained in Section 18 of the Constitution of Barbados. The court noted that it was clear from Section 13(3) of the Constitution of Barbados that breach of the reasonable time guarantee did not prevent a valid trial from being held. Additionally, in Gibson, the court noted that the competing interests of the public and those of the accused must be weighed, and the principles of proportionality applied. In carrying out that balancing of interests, the court in the instant case bore in mind that the appellant had been found guilty of an extremely serious crime committed in a most callous manner. In addition, Rajatli J. considered the case of Culpeper against the state, where the Privy Council held that a delay of over 6 years between the arrest and trial of the appellant, during which time certain evidence retrieved from the scene had been lost, had not prejudiced the appellant so as to render his conviction unsafe. The court thus held that the approaches of the Court of Appeal and the trial judge could not be faulted. At trial, no application was made by defense counsel for a stay of the proceedings owing to unreasonable delay at any stage of the trial, and no representations were made by the accused that he was prejudiced by the delay. Additionally, defense counsel never conveyed to the trial judge that the appellant had suffered any particular prejudice beyond indicating that she did not intend to call any witnesses because the persons the appellant would have called as witnesses were deceased, except for one person who was in a vegetative state. The court was therefore not of the view that the trial judge ought to have embarked upon the inquiry urged by counsel for the appellant. Further, the court found that the trial judge's direction on delay was accurate, balanced, and fair to the appellant. Accordingly, this ground of appeal failed. On the issue of circumstantial evidence, Rajatli J. agreed with the Court of Appeal that the trial judge's direction on circumstantial evidence was adequate in the circumstances of the case. The court noted that this was not a links in a chain type of case, which may have required a full direction on intermediate facts. The instance case was likened to the case of August against the Queen, where the cogency of evidence was based on the cumulative strength of the strands of circumstantial evidence. This ground of appeal, therefore, also failed. On the issue of sentencing, noting that the Court of Appeal considered that the issue of provocation and substituted the conviction of murder with manslaughter, the court was of the view that the mitigating factors raised by counsel for the appellant were not of such weight as to cause the court to revisit the sentence of the Court of Appeal. The court expressed the view that the Court of Appeal did not apply any wrong principles of law and that the sentence imposed by the Court of Appeal was not manifestly excessive. In addressing the appellant's submissions on the correctness of the trial judge's approach to the impact of the prevalence of gun violence on the sentence, Rajatli J. pointed out that this was now an academic exercise, given that the Court of Appeal did not take into account the prevalence of gun crimes in Barbados in arriving at the precise number of years of the sentence to be imposed on the appellant. In closing, the court addressed two important issues. The court lamented that the criminal justice system in Barbados continues to be plagued by inordinate delay. The court, echoing the sentiments expressed in Gibson, looked forward to a brighter day when delay will be substantially reduced, if not eradicated, in Barbados. In addition, the court noted the desirability of establishing in Barbados a modern parole board to review the eligibility of prisoners to be released on parole in circumstances where the accused is sentenced to life imprisonment with a minimum period of incarceration to be served. The court expressed the hope that the legislature of Barbados would undertake the necessary amendments to create a modern parole system to enable the criminal justice system to function effectively and justly. In all those in the circumstances and having regard to what has been read in the judgment of the court, the appeal was dismissed and the sentence imposed by the Court of Appeal was upheld. Thank you so much, President.
Thank you very much, Madam Justice Lee. Is there anything from counsel?
No, Your Honor.
Yes, okay. Well, it only remains for me to thank counsel for your submissions and for your attendance at this judgment delivery. Madam Deputy Registrar, you may close the proceedings.
Thank you, President Saunders. Thank you, Mr. Justice Anderson. Thank you, Madam Justice Rochnatley. Thank you, Mr. Justice Barrow. And thank you, Mr. Justice Burgess. Thank you, Counsel. And thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.
Thank you very much.
Good day.